Donald Trump's use of hand-picked prosecutors in red states to try to get red grand juries and red favorable judges like Aileen Cannon just took a major blow because the United States Supreme Court, in a 9-0 ruling in a case we call Abuamo, penned by Justice Kagan, just ruled that where the essential conduct takes place is where you need to indict and prosecute the person. So if you're going, like you're Donald Trump and you're trying to go after the grand conspiracy and you're trying to use a guy like Joe DeGeneva, and he's sitting in Florida with the Florida grand jury, which is apparently under the guidance of and under the supervision of Aileen Cannon, to bring in members of the intelligence community to try to testify against John O. Brennan, the former CIA director of Barack Obama, or James Comey, the former FBI director. You won't be able to use a grand jury in Florida any longer, or Joe DeGenova there, or Judge Cannon there, because you'll have to bring it into D.C. And D.C. grand juries are not the same as Florida grand juries, as we have seen. They've rejected time and time again this uncredible, corrupt Department of Justice. So if Donald Trump can't just use the local Miami, Southern District of Florida U.S. Attorney and Mr. Quinones, who's down there, and can't use Aileen Cannon, he's stuck with using judges and grand juries in the District of Columbia, which are less favorable to him. Let's go over the Abuamo case, the 9-0 decision, and why it undermines Donald Trump. And there should be a slight sigh of relief for Donald Trump's targets, because at least they'll know that the case will have to go after them where they live or where the crimes were allegedly committed, which in general has been the District of Columbia, a much more favorable district for these types of targets than, let's say, someplace in Texas or Mississippi or Florida. Okay, you're on the MeidasTouch Network and Legal AF, by the way. Take a minute, hit the free subscribe button. Help us to continue to grow our pro-democracy channel on Legal AF. Abuamo was a guy who was a Saudi Arabian nationalist who lived in America and worked for Twitter in San Francisco. And he was apparently charged with spying on other Saudi Arabian people who were critical of the government, critical of the royal family, if you will, and were considered dissidents. He was spying on them because they were on Twitter. He was reporting that information to the Saudi Arabian government, as the indictment alleges, and he was getting paid $300,000 to $100,000 to do it. And that's a big no-no, considering Saudi Arabia has already been effectively indicted by the world for having assassinated and dismembered a journalist, Mr. Khashoggi, who worked for the Washington Post, because they didn't like things that he was reporting. And they literally chopped him up and put him into garbage bags. So that's a bad thing. So you don't want to cooperate with the Saudi Arabian government when they're spying on some of their own. So when the FBI out of San Francisco, California, went to go visit Mr. Abouammo, who now lived in Seattle, Washington, they asked him about the $300,000. He panicked, according to the indictment, and he said, I have an invoice I'll send you. They said, great, send it to us when you find it. And he went upstairs and fabricated a forged invoice to cover his tracks, to show that he was getting paid not for spying on the dissidents, but for doing some other consulting. He sent that in from Seattle, Washington to San Francisco's field office for the FBI, where they received it. He was charged with a crime under the U.S. Penal Code 18 U.S.C. Section 1519, which makes it a crime to knowingly falsify a document with the intent to obstruct a federal investigation. The question is, where was the essential element or essential conduct of the crime committed? Was it when he made it in Seattle, Washington, the fake invoice, or when he sent it and it was received by the investigation? You know, that was the investigation being interfered with. So courts, including the Ninth Circuit Court of Appeals, said, it's the federal investigations in San Francisco. You're interfering with the federal investigation in San Francisco. You can be indicted in San Francisco. Not so, says the United States Supreme Court 9-0. Venue is really important to the Constitution. Venue is the situs or the location for where the trial of your peers is going to take place, where your grand jury is going to operate. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of MeidasTouch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way. And the Supreme Court said that the Constitution was so concerned about the venue issues that it's actually listed twice in the Constitution, not once but twice. So particularly in Article 3, it says that the person's venue is the state in which the crime was committed, and the Sixth Amendment says the exact same thing. So for the 9-0 judges, they made this ruling as follows, that the trial for falsifying a document must take place where the defendant falsified the document. The trial should not have occurred in San Francisco because no conduct constituting the offense happened in that location. Now, they try to narrow it down, but here's the impact. Every defendant now who's an enemy of Donald Trump or a target will now argue under Abuamo, you can't indict me in Florida if you're Barack Obama or John O Brennan or James Comey, unless any essential element of the crime you're charging me with occurred in Florida. And it didn't. Why are they in Florida? Because Donald Trump handpicked Jason Redding Quinones, who's MAGA through the core, a former state judge, who's now the U.S. attorney in the Southern District of Florida. And he likes the fact that Aileen Cannon is up at Fort Pierce. So Jason and his team drive 90 miles north to the upper hinterlands of the Southern District of Florida in Fort Pierce at the top of the district, far from home, to get a friendly grand jury that's supervised by Aileen Cannon. There's been reporting that there's been dozens of members of the intelligence community who have been subpoenaed to testify in that grand jury. And that's not the right grand jury because no indictment can come out of that. Now, Jack Smith also had an issue when he did his special counsel work where he had multiple grand juries. He had one in Washington and one in Florida. But you have to have your grand jury if you're doing that work, they have to issue the indictment. And if the indictment in Florida has to be issued in Florida. But now under Abouammo, there has to be a connectivity between the crime and the state. And there isn't one against the people in the Obama administration that Donald Trump wants to embarrass. So he would have to stop what he's doing based on Abouammo, knowing now that any indictment that came out of that could be dismissed for improper venue based on this new 9-0 decision. meaning he'd have to go now and use Jeanine Pirro. And now she's a friendly U.S. attorney for Donald Trump, but she's in the District of Columbia. And D.C. grand juries do not abide the corrupt Department of Justice. They are rejecting attempts to indict. They are multiple times. I mean, Jeanine Pirro's office has failed multiple times to have their indictments sustained by a grand jury. So now you got a relatively unfavorable grand jury system or scheme in D.C. And then you got D.C. federal judges, which are by and large liberal to moderate, certainly independent. And that's a completely different thing than Judge Cannon down in Florida. So I didn't want this to slip under the radar here on Meidas. This Abuamo case, very, very important. We'll cover it also on my podcast devoted to the Supreme Court I do with Dean Adal called Unprecedented. We'll do that over the weekend. But I wanted to get this out for you right now. If you want to read Abouammo, it will be up in Substack under Filings AF. Till my next report, this is Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.